Alright, item 18 is an election petition assigned to your lordship. We are happy that during the course of trial, your lordship will only be taking up the matter. In this case, we have filed two IA today. One is challenging the maintainability, and second is praying for deferring the filing of the written statement till the maintainability petition is decided. Your lordship,
maintainability on what ground?
On the ground that very important ground, my lord, there is non-compliance of section 81. And section 86 says if there is a non-compliance of 81, then in limine it has to be dismissed under 86.
Okay.
And there are materials to show that a petition was not presented by the petitioner in person, which is your lordship is aware where this is the mandatory requirement. So we have taken a specific ground, annexing documents to support that contention. Well, I only pray that matter may be these two IA may be called for minor.
Okay, we'll call this IA. But please tell us your schedule. How will you finish this matter? You must be aware. You are aware, and I will not give too much of, and will request.
No, my lord. I am ready today. This morning, I was requested. We were requested by the council for the other side that they want to file reply. They want to file reply. Your lordship may give them some time for filing reply.
Definitely. Therefore, okay, let the matter. We'll call.
Yes, let the matter reach.
Let the matter reach. We'll have a time frame.
My lord.
We'll have a time frame.
Always.
And if that.
Absolutely.
If suppose this is how within what time we will file objection and what will be the date for hearing? No adjournment, nothing.
My lord. 18th. Let the matter reach.
For both of you. And if we allow that it is maintainable, then again there will be some other miscase that also will finish by 7 to 10 days maximum.
My lord.
And thereafter evidence, if it further proceeds further, then day-to-day
trial.
Day-to-day trial.
Oblige, my lord. Let the matter
whether we are here or in Guwahati. It will be after other courts at around 3:30 PM in Guwahati.
Oblige.
I'll make it clear. It will not be like in any other court that we will drag it.
Let the matter reach, my lord. Let the matter reach.
Yes.
Oblige.
May I please, Your Honor?
Yes.
My lord, with consent from other side, my lord, I beg to mention item number 28, man.
28,
man.
Yes.
Since the arguing counsel is out of his station, my lord.
Matter learned counsel.
D. Tamuk, my lord.
Okay. For the petitioner? Okay. When?
After 2 weeks, my lord.
After 2 weeks. Have you taken consent from the other side?
Yes, my lord. Oblige.
My lord, I on the behalf of conducting counsel T. Taba, beg to mention item number 9.
Yes.
And conducting counsel is out of station. Therefore, this matter may fix after 2 weeks, my lord.
My lord, I may be allowed to mention item number 29. I am for the respondent.
Item number
29.
You are for the respondent.
Yes. My lord, kindly a fixed date may be given.
Huh?
Fixed date may be given.
Why? You are taking adjournment and you do take the date.
My lord, the opponent counsels, conducting counsel, he comes from other district.
Okay.
27th of November.
Who is okay? Okay. Give a date. When?
27th November. November 27th.
27th of November.
Yes.
And your also there's an interim order.
Interim order, partial shall continue till disposal of this appeal.
Obliged.
My lord, I beg to mention item number 13 on behalf of K lawyer. That
number 13. Yes.
Yes. Conducting counsel is out of station, and I have taken consent from the other part.
Petitioner.
Yes.
Adjourn 2 weeks.
Yeah.
2 weeks.
There is an interim order.
Interim order, partial shall continue till the next date of listing.
May I lordship? I beg to mention item number 23 and 24.
Item number?
23, 23 and 24.
23 and 24.
Yes, my lordship.
Yes.
Yes, conducting council is out of station. Is Modi.
Why these matters are listed today?
Uh,
Okay, IA is there. You
Order
are for
of-
petitioner.
yes, in 23, I am the necessary party, and in main case, I am the respondent.
In IA, you have filed the IA.
Yes,
Is
ma'am.
that it?
Yes.
Okay, on the prayer of the applicant, learned counsel for the applicant in IA, matter stands adjourned and be listed
After 3 weeks.
after trips. Any interim order?
Yes, ma'am.
Is there an interim order?
No.
Then why? Okay, file over. Just go through it.
Okay.
Yes, next.
May your lordship, I beg to mention item number 26 and 27. I'm from a respondent side and I have taken consent from appellant side too. I have taken consent from appellant side too.
26, 27, appellant. Appellant 7, after 2 weeks. After 2 weeks,
After 4 weeks, kindly.
after 4 weeks. You will face this music after 1 or 2 years. Then you will cry to argue cases like Guwahati. Yes, next.
May I, Your Lordship? Your Lordship, I beg to mention item number 19.
Yes, 19 and 20.
Yes, Your Lordship. Lordship, this matter may be listed on 7 since the council is out of station.
7th of
7th of November.
May I, Your Lordship? Your Lordship, I'm here for the standing council on behalf of standing council, Your
Apex
Lordship.
Bank.
Apex Bank. Your Lordship, this matter is listed on orders column. It may be listed on admission column on next date.
Service is complete.
Yes, Your Lordship, pleadings are complete.
Pleadings are also complete.
Yes, Your Lordship.
Okay. This matter is ready as regards service and pleading. Accordingly, list this matter in the admission column when?
7.
7th of November.
Sorry, November 7.
Deeply obliged.
Where is the affair? How many days and where is the affair?
Page number 19, my lord. Now from 18/6/2024 by my lord. 19.
Boy is recovered? The victim is recovered?
Yes, subsequently passed away.
Okay.
302.
When? 302?
Yes.
When? Case diary?
No, this is for.
Okay, searched. Okay.
TCR.
Sir, case searched case. Registry to call for the case record of
They have not given the GR number, they have mentioned the use case number, page 65. Page 65,
page 65.
drawing PS case number.
Record of case record. Yes, how, why they have not given? Nothing is there, any CR number in the affair?
No, my lord, not here. I thought they mentioned my lord drawing PS case number pending before the balance for case.
No copy of search sheet.
Charge sheet is there, my lord.
Where is that?
Page 25.
Page 25.
I have a certified copy of it.
Page 20, isn't it?
Yes.
Any search sheet number?
01, my lord. 01 2024.
01 of,
2024.
where do you get that?
Yes, I'm sorry, ma'am. I'm sorry.
Case 37.
Final report matter
Uh-huh.
01.
Okay.
Serial number.
Okay. Call for the record of case record of case record of rowing PS case number 14 of
2024.
2024 for 2024, which was culminated into a search sheet being search sheet number 01/2024 dated 11/5/2024 11/5/2024, which is now pending for trial before the learned session judge Teju. Full stop. Along with the aforesaid case record, the registry shall also call for the scanned copies of the case diary of the aforesaid police station case. Place this matter on
Next Wednesday.
will it come? Okay, next Wednesday. Tuesday, we'll make it Tuesday. Wednesday, everybody will leave. We'll try it on Tuesday. You just all that pretty good. Any trial comments? Any evidence?
13 CC.
Okay. Yes, what is this?
This is the application under 588.
For crossing of
FIR and subsequent charges.
joint petition?
No,
Okay, where is the FIR?
page number 9.
Page
19.
19. You are Kepe Lambi.
Yes.
What is this criminal heart? Mr. You are Mr. Swenso, learned counsel for the petitioner, also heard Mr. Swenso, additional public prosecutor. The present application is filed under section 528 of BNSS for quashing the criminal proceeding arising out of FIR number 90/2022, registered under section 376 of IPC dated 9/2/2024. Full stop. After completion of investigation, the investigating officer has already filed search sheet. Full stop. From the materials available on record, it is seen that the primary allegation lodged by the informant is to the effect that the informant and the accused had a existing relation for 5 years. However, the informant is not maintaining any relation with her. In view of the aforesaid allegation and considering that both the persons are major, this court is of the prima facie view that there may not be any case under section 376 IPC. Accordingly, let a notice be issued, returnable after 6 weeks. Accept notice for respondent number 1 to registered post with AD as well as both ways. Good, sir. Considering the matter in entirety, it is provided that the further any search sheet file.
Yeah.
Trial comments, Your Lordship.
Huh?
Trial comments.
Trial comments. It is provided that until further order, the proceeding of
Case number 1
Session case number 1/2023 pending before learned session Judge UPR shall remain suspended.
The TCR may be called for.
Huh?
Copy of TCR.
You
Scan copy of file code.
In the meantime, registry shall procure the scanned copies of the case record of the aforesaid case as well as the case diary of so-and-so PS case number.
Deeply obliged, Your Lordship.
Yes, what is this?
Your
Lordships, begging to appear through BC in this matter. This is a quashing petition, my lords, under section 528 of the BNSS. The
Quashing of
FIR,
FIR?
yes, my lord, the FIR and FIR charge sheet and order of charge, my lord.
Where
The
is the
charge
FIR?
sheet, my lord, the FIR complaint is at P16, page 16, your lordships. Annexure B, page 16. This is the complaint, my lord. The charge sheet, my lords, will be at page 22. Operative portion being at page 25.
Okay, then
Naraj, the foundation of the case is that there was an eyewitness, Srimati Siring Ribia. Her 161, my lord, is at page 30, where she says, I have not seen anyone. I cannot identify anyone. I have not seen anyone. Page 30, her 161 is there. There is also, my lord, a certificate at page 18 saying that I was a headmistress. I was about 150 kilometers away
where is
attending
the
to my duty.
order of framing charge?
Yes, my lord. That is annexure F at page 43. No one else is identified. They say 11 people did this act. Only a singular individual is identified who happens to be the wife of the individual that the complainant is admittedly having relations with. Page 43, my lords, annexure F.
What is 448
Trespass.
Your lordship, house trespass.
House trespass.
and 427?
Which he caused damage amounting to 50 rupees, Your Lordship. Your Lordship, but the offense alleged to have been, Your Lordship, presumed to be committed, Your Lordship. Offense has been committed. Your Lordship will find in page number 31, Your Lordship, the statement disclosing the name of the accused, Your Lordship. And motive is also there, Your Lordship. Because the complainant has an illicit relationship with the husband, so motive is clearly cut there, Your Lordship. Why wife went there and caused all these ruckus, Your Lordship. It clearly says, only I have seen Madam Bagra. In last paragraph, Your Lord, last is
Page 30.
31, Your Lordship. Identified, Your Lordship.
You are Litar Bagra Doe.
Yes, Your Lordship. And
Now, if
with
you
regards,
go,
yes,
this is a statement of whose statement? This is page
now
31.
this is exactly, my lords. Page, the statement is of T. Tacha. This is a statement of Gopi Riba, Gopin Riba. And Gopin's Riba's name is absent in the Chalan. My lords may see, Gopin Riba is not mentioned by the police at page 25 at all.
Is this Gopen Riba listed witness?
Gopin Riba, my lords, is
a
listed witness 3. Yes, my lords, listed witness 3.
Then
My lords,
we are
may
not
kindly
doing her trial. Prima facie says that your Lieutenant Bagra was parked her card opposite my shop, got down from her card with holding seal on her hand and went up to the rental building.
Yes.
There are other evidence that rental building was ransacked.
Yes.
Why should we now decide that
So, my lord,
nothing is
Yes.
I'll answer that, my lords. My lords, may I allow me to place on record certain judgments?
While answering, you remind yourself, and we are also
Yes, my
reminding ourselves that we are not doing a trial. Rather, you are in a limited ground of quashing, and these materials
Yes,
are
my lord.
available before us.
Yes, my lords. I understand that completely. Now, my lords, if I was to take this material at face value, admittedly, there is a situation in which the stated eyewitness is a lady by the name of Tishin Ribia, my lords, who at page number 25 is supposedly the individual who calls the complainant and says, I have seen the petitioner enter your house to ransack it. Her 161 is at page 30, where a categoric question is put to her. Did you see Litir Bagra Doer and her group were broken open the door lock and damaged the household items of Miss Jona Garia? The answer is no. I did not see Srimati Litir Bagra and her party who were entering in the rental room of Miss Joina Garia and damage all the household items. I came to know from accepted. Now, my lords comes to the my lord may see the complainant's version.
She or he is not an eyewitness.
Yes, my lord. Now, yes, my lord. Now, my lord may.
So, will that mean? Okay, will that mean? Can we at this stage now say, since she was cited as eyewitness, she in her statement she cannot be treated as eyewitness. Therefore, all other witnesses who saw you with stick and all should be discarded at this stage.
Exactly. The answer to that, my lord, would be in certain Supreme Court judgments. I'll just place them on record. What is it that those judgments say? Those judgments say that while, yes, my lords may have the first judgment, which is a recent judgment, Muhammad Wajid versus State of UP.
Not this is the first judgment. This is the first judgment.
Muhammad Wajid versus State of UP, my lords. My lords will have the factual matrix of this case, which is at paragraph number 3. They have reproduced the FIR. The undersigned Rajkumar, son of Sadhuram, my lord, has it, paragraph 3. The undersigned Rajkumar, son of Sadhuram, is a resident of Kasimpur Police Station, Mirzapur. I want to submit that Haji Iqbal and his son Javed Wajid, Alisan Ajifa, and brother of Iqbal, namely Mahmood Ali, forcefully started to tell us since long that our land bearing Khasra number 256/1 situated at village Mayapur belongs to them. It is in the year 2021 when time for cultivating arrived that myself and my brother Rajkumar went to the house of Iqbal, son of Abdul Wahid at Mirzapur. We requested him that you people are disturbing the peace and tranquility of us. We said we are destitute. It is on that Iqbal and his brother Mahmood and his sons Jaibad, Wajid, Alisan and Azal became very furious with us. They started using abusive language against us. We requested them to stop uttering abusive language. It is at that time that all these persons assaulted us with their hands and fists for a long time. It is thereafter that they got that on a point of pistol put on my forehead. They took away 2 lakh kept in my pocket forcefully. Thereafter, all these people stated that if we would talk to anyone, they would kill all of the members of our family. It is then Iqbal told me to sign the stamp paper. After terrorizing and threatening us, they compelled we both brothers to put our signatures on the stamp paper. We being robbed, we returned silently to our home. So allegations of beating of 327. Now, my lords, may come straight away to what the court says at page 30. And remember, in this case, my lords, the incident takes place on 5/10/2020. There is a delay of 5 days. And then the complaint is made on 10/10/2020. So there is an admitted delay of 5 days in this case. Point 30, para 30, my lords. At this stage, we would like to observe something important. Whenever an accused comes, para 30, my lord, para 30,
30.
30, my lord, 30.
At this stage.
Yes, yes.
At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the Code of Criminal Procedure or extraordinary jurisdiction under article 2 to 6 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive of wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive of wreaking personal vengeance, then he would ensure that the FIR complaint is very well drafted with all necessary pleadings. The complainants would ensure that the averments made in the FIR complaints are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments. If need be, with due care and circumspection, try to read between the lines. The court, while exercising its jurisdiction under 482 CRPC or Article 2 to 6 of the Constitution, need not restrict itself only to the stage of a case, but it is empowered to take into account the overall circumstances leading to initiation, registration of the case, as well as materials collected in the course of the investigation. Now, the reason why I'm saying this, my lord, we have now a situation in which admittedly there is a affair going on. Admittedly, there is a divorce proceedings going on, and my lord will see something which is startling, which I have not seen till now. My lord may see the order at page 43. Look at what the court is saying. Learned DC has submitted the parties are not interested in settlement. My lord, in a criminal case, and I say this with all due respect, why is the court forcing my client to go into a settlement?
You will not
Page
understand.
43.
You will not understand this until and unless you visit this region.
I understand this, my lord, which is why I'm saying.
You will not understand that until and unless you visit this region and look into the local customs.
I understand, my lord.
Yes.
The circumstances
So
of this case are such.
don't make that argument here. This is something different. Here
I
the law
understand
is
that.
here is law is customary. A
Yes, my lord.
second marriage is permissible. If you give a mithun, there can be compromise. So don't say this. And this customary law is accepted by statute.
My lord, I understand all
Yes.
of that.
Yes.
I am only submitting that in the facts
Therefore,
of
don't
this
say
case.
that judge has exceeded his jurisdiction.
No, of course not. Of course not. I am only saying that the overall circumstances are such that criminal proceedings are being used in a vexatious way to force me to compromise. Even under customary law, there is no forced compromise, my lord. To the best of my knowledge, customary law does not say that an earlier wife can be forced into accepting a second wife. Now, with regards to the averments here, Tising Ribia admittedly, the case of the complainant is, I got a call from Tising Ribia. She identifies Litter Bagra Doe, the petitioner. Under 161, Tising Ribia says, I have not seen her. There is an official document, my lords, which is at page number 18. It is an official document under the Evidence Act. It has the presumption of genuineness. Evidence Act is applicable in Arunachal, my lord. It says I was doing my duty on that day at that time. It says that on that day, or at 5th October 2021, I was on duty at Government Secondary School, Laktaung, Changlang. Now, to force me now, my lords, to go through the rigors of trial while my husband has initiated divorce proceedings, it is also an admitted fact that now my husband has initiated divorce proceedings against me. This will be, and I say so with the deepest respect, the very definition of vexatious and malicious prosecution. This document, my lords, is not refuted by anyone. The challan doesn't say that this document is fake. The challan doesn't say this is a forged document. It is dated 13th of October. The final report doesn't say that we have not gone and checked. A duty of care, my lord, of proper investigation is old. If I was on duty in Changlang, then admittedly I cannot be at two places at the same time. The main eyewitness does not see me. The complainant is the second wife or a lady who my husband is having relations with. That is admitted. It is also admitted, my lords, that out of 11 individuals, kindly note what the complaint says. Complaint says Litter Bagra Doer along with 10 people, 5 male, 5 females, came and trashed my house. No one is identified. Please note, this individual who identifies me, he is a shopkeeper who says out of 11 people, I only identified one person who is Litter Bagra Doer. I am not, my lord, with all due respect, Susmita Sen, who my face is not identifiable to everyone and anyone. This man does not say, how do I know this person?
The difficulty. This is the difficulty.
BC.
Inform into the difficulty. Yes, we are not getting your voice clearly.
Ma'am, my lord, am I audible now?
Now, yes. But it breaks.
Am I audible, my lord?
Yes.
Yes, my lord. So I am only saying, my lords, that in these circumstances, when I have an official document, admittedly an official document, the charge sheet does not say this is a procured document, this is a forged document, saying that I was attending to my duties at Changlang.
It is a prosecution document. According to you, this is a document
Yes,
relied
yes.
by the prosecution.
I can show that also, my lord. I will show where the prosecution rests upon it. I will just show it, my lord. My lords may have page number 32. My lord will have page number 32. This is the 161 statement of my husband, who is also the Deputy Director of Education. Question number 2. Officially, you are holding at the end of page 32, my lords. You are holding the post of DDSC District Changlang and responsibility of Administration of Education
So
Department.
this has been issued by your husband.
Yes,
No,
Your
my
Lordship.
lord. No,
This is
no,
issued-
no, no.
Huh?
No, look at it, my lord.
This
It
is
Yes.
Mr. Ego Doe.
Yes, has issued by husband, Your
Now,
Lordship.
look below. He has not signed it. Look who has signed it. It has been signed for
Oh, he has
DD
signed it.
No, no, my lord, below that.
Oh.
For DDSC Changlang, District Changlang, it has been sent to everyone. A copy of it has
For
been marked.
DDSC Sanglang, it is signed by your husband.
My lord, Ego Dayal's signature is above. The individual who signs it for DDSC, his name is not there. It just says for DDSC.
For DDSC, who has signed? The DDSC may come tomorrow in the witness box and say that I have not authorized. Can we decide?
He's not a witness. He is not a witness. He is not a witness.
So who will prove this document then? This
But
document is
in
not
my-
validity. Because
my
this is
lord,
your,
mine-
this is not, you are having no signature. Can we at this stage go to all this?
My lord, which is why I showed the Supreme Court. judgment.
If the author of this document is not an witness, what is the value of this
My
document?
lord, which is why we showed the Supreme Court judgment that the overall circumstances have to be seen.
We'll deal with. We are
Yes,
dismissing
my
your
lord.
petition.
Yes, my lord.
That's
My
all.
lord, Yeah, my lord, may allow me, there is a small compilation and compendium that we have created. My lords may allow us to proceed to place that on record. These are basic judgments, my lords, on
Oh, that's not necessary. All these judgments are not necessary.
yes,
You
my
have
lord, but
given this judgment. This judgment deals with all, is from Bhajanlal to everything.
Yes.
yes, my lord, Muhammad Wajid.
When everything is covered in this judgment, why
Yes,
should
yes.
we cite many
No, of
other
course.
judgments?
Of course. Muhammad Wajid deals with everything, my lords.
This is deals with Muhammad Wajid deals with everything.
Yes. Admittedly so. Admittedly so, my lords.
Heard. You are Mr.
Abhimanyu Tiwari, my lords.
Learned counsel for the, give them his name. Yes, learned counsel for the petitioner, also heard Swensu. The present application is filed by the present petitioner under section
528 BNSS.
528 BNSS for quashing and setting aside criminal proceeding against the petitioner in connection with FIR number 215 dated 11/10/2020. FIR number petitioner in connection with Itanagar PS case number 215 dated 11/10/2024. Full stop. The further challenge is the order of framing charge dated 23/9/2024 passed by the learned Chief Judicial Magistrate UPA in GR case number 564/2023. Full stop. The learned counsel for the petitioner submits that the present criminal prosecution is nothing but an abuse of the process of the court, as well as its prosecution lost by the informant, who is the wife, who is the anyway, we will not say that. The learned counsel contends that there was a delay of 5 days between the alleged occurrence and intimation being given to the police, inasmuch as the alleged occurrence took place on 5/10/2020 and the FIR was registered on 11/10/2020, and such delay has not been explained, and on this count alone the entire proceeding is liable to be quashed. The mala fide intention behind lodging the FIR is clearly available on record, inasmuch as the complainant and the husband of the petitioner are having an extramarital affair, and only to pressurize the aforesaid affair has been lost. Referring to the statement of one Tersing Riba, who is projected by the prosecution, referring to the statement of Srimati Tersing Riba, statement of Tersing Riba recorded under section 161 CRPC, whom the prosecution has projected as an eyewitness, the learned counsel submits that the said eyewitness has specifically stated that she has not witnessed the accused person in committing the offense. Therefore, according to learned counsel, submits that in view of such statement recorded, the entire prosecution is liable to fall, and therefore the petitioner should not be allowed to face a malicious prosecution. Full stop. And therefore, this is a fit case where this court can exercise its power under section Swensu BNSS. referring to the determination made by the Honorable Apex Court in the case of Muhammad Wazid and another versus State of UP and others, the learned counsel contends that the present criminal proceeding launched against the petitioner are manifestly frivolous and vexatious and instituted with the ulterior motive to wreaking vengeance in view of the extramarital affairs as recorded herein above. Therefore, the learned counsel further contends that if the statements recorded by the investigating officers are taken as a whole, no prima facie case is made out, inasmuch as none of the witnesses could identify any of the persons who committed the alleged offense. Therefore, on this count, the petition is liable, the criminal prosecution is liable to be quashed. Referring to prosecution document, which is also annexed along with this quashing petition, the learned counsel submits that the said document is a certificate which was issued by the DDSC Sanglang, certifying that on the fateful day, that is on 5th of October 2020, isn't it?
Yes, sir.
To 2020, the petitioner, who is a headmistress of Gov Secondary School, Laktong Sanglang, was very well present in her duty. Therefore, in view of such admitted document by the prosecution, the entire proceeding is liable to be quashed, coupled with the statement of the eyewitness, projected eyewitness by the prosecution, that the said eyewitness did not witness the petitioner committing the offense. This is your argument?
Yes, Maharaj.
Okay.
One bit more, that the witness who identifies me does not say how he knows me.
Okay. It is further contended that though one witness, namely, what was her name? Page 30.
31, your lordship.
Page 31.
Gopin Riba Kamduk.
Stated in her 161 statement that she witnessed the petitioner entering into the house with what was in her hand?
Your lordship, with your lordship, dao and other thing, your lordship.
Stick.
With weapons in her
on her hand.
We'll just correct it. What is the weapon?
Yes.
Weapons in her hand. However, there is nothing on record to show how the said witness knows the present petitioner. Therefore, such evidence of such statement of such witness is liable to be discarded for the purpose of consideration of the present case. Per contra, learned counsel for the learned additional public prosecutor submits that if the materials collected by the prosecution, including the statement of the witnesses, are taken on its face value, a prima facie case under section 447 and section
427.
448
and 427.
448 and 427 are made out, and therefore the learned trial court has not committed any error framing the charges. Full stop. Referring to the statement of witness, namely so and so, the learned counsel, additional public prosecutor submits that the said witness has clearly stated the role of the petitioner in commission of the crime. Therefore, this court may not at this stage like to re-evaluate such evidence, and the same shall be subject matter of the trial. Therefore, the learned counsel prays that this petition is liable to be dismissed. heard the learned counsel for the parties. Also, peruse the material available on record, including the statement of the witnesses, the FIR, and the search sheet. The FIR, in the FIR, it is alleged that on 5th of October 2020, at about 9:10 a.m., the petitioner, is not it? Litar Bagra Doe, petitioner, along with 10 other persons, forcefully entered the rented house of the
Complainant victim.
complainant by breaking the lock with hammer, and the said perpetrators have was armed with local dao, iron rod, and stick with an intention to harm her, and they stolen away different items which are disclosed in the affair. It was further alleged that the said persons has damaged other properties inside the house. It was also alleged that the petitioner has threatened to kill the informant, and if she finds
Anywhere.
the informant anywhere, she should seriously harm the informant. Accordingly, the affair was lost. After completion of the investigation, the investigating officer has filed a search sheet. Full stop. Amongst other, the search sheet has concluded the following. Page 25, pencil mark to pencil mark. Subsequently, the learned trial court, after perusal of the material by the impugn order dated, page impugn order dated
43, Your Lordship.
page 43. Impugn order dated
23/9/24.
43.
Yes, Your Lordship. Next are F. Last page, Your Lordship.
43. Framed charges under section 448/427 IPC. However, the charge under 506 IPC was dropped. 506 as well as section 379 IPC was dropped. Now the trials has commenced. The learned counsel is correct. The Honorable Apex Court in Muhammad Wajid and Muhammad Wajid Supra has, after dealing elaborately with the provisions of power of revision as well as power of revision so far some released to the quashing of affair/search sheet, has laid down the following proposition. 1. The court is to look into the averments made. Load down the following proposition. It will not be just enough for the court to look into the averments made in the affair/complaint alone for the purpose of ascertaining whether necessary ingredients to constitute the alleged offense are disclosed or not. 2. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above averments made. Third, the overall circumstances leading to the initiation/registration of the case as well as materials collected in the course of investigation is to be looked into. In view of the aforesaid stated proposition of law, this court has perused the entire material and the intent in circumstances under which the alleged affair was lost. It is on record that where is that relation? It is on record as well as reflected in the search sheet that search sheet page
26, 26, 26.
25, 26.
Second paragraph, 26.
reveals that the husband of the accused, Sri Igo Doye, had extramarital affairs with the complainant, and out of anger, the accused went to the complainant's rented house located rented house with pre-plan to assault the complainant. It was the complainant. Thus, one of the reason as projected by the prosecution, one of the reason of the attack, as projected by the prosecution is the extramarital relation between the husband of the accused with the complainant. It is true that this is an important circumstances under which the attack was done. However, such extramarital affair, in the considered opinion of this court, shall not give a liberty to a person to criminally act. Therefore, this court is to look into what are the materials and statement made by the witnesses. Made by the witnesses. Now, it is also correct, as urged by the learned counsel for the petitioner, that the eyewitness projected by the prosecution has, in her statement recorded under section 161 CRPC, denied witnessing the incident. However, page 32. Page 32, na?
31.
However, another witness, namely Gopi Riba Kamdup, specifically stated that on 5th of October 2020, when he or she was when she was at her shop, she saw the accused park her car opposite to the shop of such witness and got down from her car with holding stick on her hand and went upward the Rendell building where the informant was staying, and some group of people was following her. And after a few minutes later, she intimated the informant, is not it?
Yes, one of the witness, Your Lordship.
And intimated intimated the informant.
No, my lord, the witness. This is Rabia, who says she
called on phone to another witness.
Yes,
to another witness.
Sring Ruba.
As this witness suspected the violent attitude of the informant. Full stop. If such statement are taken to be correct in its totality, it suggests that on the date of the incident, the accused went to the place,
Place where complainant.
rented house of the informant with what is thou?
Thou, stick,
With weapons such as stick and dao in her hand.
My lord, this witness
Here-
does not say thou. This witness
Huh?
only says stick. This witness does not say thou. She only says stick.
Stick.
Only stick, no
Don't
thou.
say down. Stick.
stick.
Full stop. There are materials on record to suggest that there was ransacking of the house.
Yeah.
Therefore, at this stage, this court, in exercise of power under so and so, will not be in a position to weight the statements of these witnesses and to determine which one is correct and which one is not correct. Whether which one is not correct. Now coming to the plea of LAB,
Page 18.
plea of LAB and the documents relied on by the prosecution, it is seen that a certificate was issued on behalf of
Annexure C, Your Lordship, page
Huh?
18. Page
Page?
18. One
page
18.
18.
Yes, Your Lordship.
Certificate was issued by the deputy, signed by Deputy Director School Education Sanglang on behalf of, Deputy Director Sanglang.
Issuance date may be recorded
Huh?
also. Date of issuance may be also be recorded. 13th October 2020.
Issued on 13th of October 2020. Which happens to be his husband, Doe,
Though his husband, Your
Ah.
Lordship.
who happens to be the husband of the accused.
Yes.
Be that as it may, this court at this stage cannot conclude on the basis of such document until and unless proper evidence are taken that the petitioner was not present,
Yes.
was in fact present in her school, not in the place of occurrence,
Yeah.
which shall be a subject matter
Right.
of the trial. Full stop. That be the subject matter of the trial. Therefore, after perusal of the FIR, the search sheet and the materials available, and after assessment, this court is of the view that prima facie case under prima facie offense under section 448 and 4/427 is made out. It cannot also be said that the materials collected by the investigating authorities are not legal evidence,
This is
which shall finally be subject matter of the trial.
Yeah.
And this court, in exercise of its revisional power, is into have must have a bird's eye view and cannot weight those evidences
Yes. Inherent power, Your Lordship.
in inherent power. It cannot also be said that the statements recorded by the investigating authorities are inconsistent with the accusations made. Full stop. Therefore, this court, in exercise of its inherent power, would not like to embark upon an inquiry whether the evidence in question is reliable or not, or whether on a reasonable appreciation of its acquisition would would not be sustained. And it is well settled that such exercise of power is the function of the trial judge. In view of the aforesaid, the present revision petition stands dismissed. However, while parting with the record, it is made clear that observations made in this court, made in this order is for the purpose of exercise of its inherent power, and same shall not influence the learned trial judge in determining the matter on merit.
Deeply obliged.
Obliged, Your Lordship, obliged.
What is the judgment? Give it to me. Give it in the file.
Yeah, Your Honor.
Yes,
This is a joint application filed by the accused and the victim complainant as in petitioner 1 and 2.
where is the affair?
As far as page number 17 is type copy. May I read?
I am not getting anything. What is the allegation? What inquiry?
So this complainant is also SI lordship with the investigating officer. The day lordship, there was some party was going on, birthday party, and he after receiving the complaint, he went there.
Obstructing,
Yes,
obstructing police
during the
officer. How
investigation.
can that be compromised? How the police officer can compromise this offense?
That's right, lordship.
Huh?
And moreover, lordship is department lordship may be involved because they on the duty lordship.
He was on a
That's
duty.
lordship.
He has been obstructed. He lost an affair. Now, how can he compromise that? On the prayer of the learned counsel for the petitioner, matter stands adjournment listed after 2 weeks. Best option. Or a dictation again for 15 minutes. Which one? After 2 weeks.
Apply.
Yes, Tama.
Lord, in this case, we have put to challenge the impugned order. That is at page 27.
Page
27.
Who is for the respondents?
And Taji.
Where is he? This was passed by?
The village authority, customary court.
Okay. Now against that, what is the issue? What was the issue here?
Issue was, my lord, initially I was the complainant, man. And my complaint is at page, my lord, page 17, man. There was some transaction of local bills during the course of business of that local bills. And there was some dispute. So accordingly, I have lodged the complaint. And then last one, without giving any counter claim.
None, we are enjoying an interim order. Enjoy that. So Mr. Tama is present for the petitioner. None appears for the respondent opposite parties. Pleadings are complete.
Complete.
Pleadings are complete. Accordingly, admit this matter for hearing. Stop. And be listed after 2 weeks.
2 weeks.
2 weeks. Stop. The interim order passed earlier shall continue till disposal of the revision petition.
Hello.
Lordship, so item number 678, this item number 6. This matter is actually represented by my friend Mr. Menal Kalita from Guwahati.
Okay.
That is why he was seeking adjournment so that the next this matter may be fixed for next day, so that the matter
When
can this matter be fixed for hearing
What is the issue here?
Issue is only this item number 6 is something different. This is this.
Why these matters are together? Basically, what is the issue? Any quashing of FIR or any against
No.
any conviction,
Just-
search it?
Just pictures,
Hmm?
not passing of the affair. Pictures from that being a party in the case.
Okay, they have been,
There, no prima facie case has been made out against.
so you are, so they were not discharged, that framing of search you are challenging here.
Yes,
There is a stay.
yes, no mistake.
Now, what is the stage of the trial?
This is appearance. Appearance is going on.
When can we take,
Charge has not yet been framed.
search not yet framed?
Not yet been. No
Okay,
mistake.
then we'll adjourn it. When can you, what is this?
After 2 weeks, any.
Give a date because he's an
particular date
outstation
is-
lawyer. Again, same, as per his convenience, give a date. Because this was not fixed matter. That's why we can
November-
understand that he's not ready. He might not be ready. So we'll fix a
November-
date as per his convenience.
November 11.
November 11.
Yes.
It is submitted that Mr. M. Kalita, the arguing counsel, is an outstation counsel and he could not appear today due to personal difficulties. Accordingly, a prayer for adjournment on his behalf is made. Prayer stands allowed. Release this matter on
November 11. November.
11th of November 2020.
All other matters.
6, 7, 8. You pass a common order, 6, 7, and 8.
All right.
You have put a respondent.
Yes.
This is first appeal,
Second appeal.
second appeal.
Today, they were supposed to argue on the substantial question of law.
That yesterday's matter.
Lordship,
None appears for the petitioner on call. List after 3 weeks.
obliged.
Though MS.N. Dragon is for the respondents is present.
Yes,
Full stop.
obliged.
However, in the interest of justice, matter stands adjourned and be listed after 3 weeks. Yes, Dicky.
If it is your convenience, it can be disposed, my lord.
Dispose of.
Yes, proceedings under order 21 rule 41 was going on. No application, nothing, my lord. Proceedings started under order 21 rule 37. For arrest.
Where is the order?
Order is it, my lord? Page 103.
Need the CPC.
This was a proceedings under, my lord, order 21 rule 41 for declaration of assets and properties to satisfy the decree drawn in favor of the respondent. However, that was going on. All of a sudden, my lord, no application, nobody filed, my lord. My lord, will proceed, I believe. Nobody approached the honorable executing court.
What is the earlier stage? What is the earlier date it was fixed for?
My lord, there's so many orders, my lord. In fact, it starts from 100, page 100, where first this came to be passed. Page 100, this is the first order. Before that, my lord, initially, my lord, will start from,
So what was pending? You said order 21 rule?
41, my lord, for declaration of assets and properties.
Ah.
That was going on. We have done it.
That is reflected at page 20 also.
Yes.
6/5/2024.
Yes. Then while this was going on, my lord, nobody.
You are the judgment debtor.
He is the judgment. Yes, I am the judgment. I am the judgment. Sorry, my lord. Yes.
You are a decree. holder.
Yes, yes, lords. And nobody approached the executing court.
You
my lord.
proceed, will request, you complete it there. what will do warrant and all? Anything will serve, anything, what the benefit you will get from this?
Yes,
A decree will not be executed
I have
ultimately.
filed my properties. My properties are not here. We will have to file an attached application there at Western District.
Ah.
That is reflected in the order also.
Which order?
That was page 65, madam.
Page 65.
Yes. Paragraph 3. Yes, madam. On perusal, it appears that some of the properties are situated beyond the territorial jurisdiction of this court. Hence, this court cannot pass order for attachment of property situated beyond
Page
the
63.
65. Paragraph 3, madam. It appears that some of the properties are situated beyond the territorial jurisdiction of this court. Hence, this court cannot pass order for attachment of the property situated beyond the jurisdiction of this court. Decree holder is directed to file appropriate application for attachment of property which is within the jurisdiction of this court.
That has
Now,
been filed.
Only judgment chapter number 1,
Hmm.
that is one Mr. Tarku, he has property here. That
Hmm.
has also not been filed.
So that application attachment is not filed.
No, nothing has been filed.
To
madam.
get it,
This
get it
order-
executed, there is a provision, even if it is outside
Yes.
jurisdiction of this court, there is some provision, it can very well do this.
My lord, this is a case, my lord, the judgment did not file any application. He did not even want my arrest, my lord.
What,
Suo moto, this has been done. From page 100.
will allow this?
Yes, Lord. With the direction that the learned court below shall proceed the
You
execution. as-
file it, then only court can
No,
do.
no, proceed as per law.
Oh, as per law, that will say,
suffice.
that will say.
Yes.
That will say. The present application is filed assailing an order dated 7/6/2024 passed by the learned civil judge senior division, capital complex at UPR in money execution case number 21/2016. Whereby civil warrant of arrest against the petitioner was issued. With a direction to the decree holder to submit subsistence allowance of rupees 5,000 in favor of jail superintendents. The litigational history shows that the respondent as plaintiff filed a money suit being money suit number 34 of 2014, which was decreed by the learned trial court. An appeal preferred by the present petitioner being RFA number 03 of 2017 was also dismissed.
Still pending. for the-
2017 is still pending for adjudication before this court. There is no stay.
My lord,
RFA no stay.
no stay because I was not in the position to furnish the secretary.
Okay, okay.
That is the
Okay.
because I have a former
Okay,
MLA,
that-
but I lost my elections, I've lost everything.
So election has killed you.
Yes.
Anyway. In the meantime, as there was no stay order passed by this court in RFA 03 of 2017, money execution case was proceeding. Money execution case being money execution case number 21/2016 was proceeding.
Yes, 56.
Was proceeding. It is seen from the record that for the purpose of execution of the decree, the learned executing court directed the decree holder to declare the properties for the purpose of execution.
Because the execution was, petition was filed under order 21 rule 41.
On an application filed by the decree holder under order
21
rule
41.
41. While the aforesaid application was pending, the decree holder has also made declaration of his properties.
Judgment debtor.
Judgment debtor has also made declaration of his properties, which is recorded by the learned executing court in its order dated 25/6/2018. Thereafter, on 18/4/2019, the learned executing court directed the decree holder to file appropriate application for attachment of property, which apartment of properties which is within the jurisdiction of this court, and to do needful for those properties which are beyond territorial jurisdiction of the executing court. While the matter was proceeding at that stage and no application was filed, suddenly on
Initially, my lord, at page 100.
Suddenly on page 100, no?
Yes. 18/12/2023. Suo motu, my lord, proceedings
okay.
began under order 21 rule 37.
Suddenly on 18/12/2023, the learned on its own issued so cause to the judgment debtor to appear before the court on the next date and to show cause as to why they should not be committed to civil prison as per order 21 rule 37. Subsequently, by the impugn order dated 7/6/2024 was passed. Full stop. In the given facts of the present case, more particularly when the judgment debtor has participated properly in the before the executing court, declared the properties that can be attached for execution, there is no necessity for issuance of the warrant of no necessity for passing the impugn orders, inasmuch as the condition precedent as required to put a person in civil prison on execution for execution of decree was also not available and or discernible from record. In view of the aforesaid, this court is of the view that the learned executing court has exceeded its jurisdiction while passing the order, not only exceeded its jurisdiction, but also failed to exercise jurisdiction while passing the impugn order dated 7/6/2024, and therefore the aforesaid impugn order, so far the same relates to issuance of civil warrant of arrest against the judgment debtor, stands quashed. Full stop. The learned trial court therefore accordingly proceed as per law in the execution proceeding.
Okay.
Please, Your Honor. And I'm sorry for the interruption. I was supposed to appear for item number 10. And I've been instructed to withdraw the petition, Your Honor, because when we filed the petition, the decree was not yet passed.
Okay.
And we've only recently come to know that on 16th, a decree has been passed.
Intimate, Madam Nikita.
I've intimated.
So you want to withdraw?
Yes, Your Honor.
Okay.
With the liberty to file again.
The learned counsel for the appellant submits that while filing this present application, the decree was not present appeal, decree was not available, and subsequently she has received the decree, and therefore she may be allowed to withdraw the present second appeal with a liberty to file a fresh petition incorporating the decree passed. Prayer is not opposed by MS and Drangan, and therefore stamp stands allowed.
Deeply obliged.
With a liberty as prayed for.
Deeply obliged.
Disposed of. Okay.
Lordship,
Yes,
I have been instructed to withdraw this.
the learned counsel for the petitioner. Your name, please?
S. Yirang, Lordship.
S. Iraru. Huh?
Yirang, S. Yirang.
S.
Yirang.
Your name is there.
No, my name is not reflected here.
Huh?
My name is not reflected in the course.
On behalf of
L. Perme.
L. Parve, Mr. Swensu, appearing on behalf of Ms. L. Parme, learned counsel. L. Parme's name is there?
Yes.
Yes, A. Parme, learned counsel for the petitioner, submits that they have instruction to withdraw the present petition. In view of the aforesaid submission, the present petition stands closed on withdrawal.
Thank you, Lordship.
I know this case is pending in the same stage. Even after passing 12 months, that is 1 year.
No, offense is under
Under section 376 2F.
376
2F.
2F. What is the punishment?
10 years.
Now, the informant is not appearing.
No, Lordship.
How notices were steps were taken?
What had happened? The victim was earlier in the custody of CWC, Child Welfare Committee, Italy. And I have taken step for that location. Now, after knowing that she has been shifted to Ojo Mission, I have again taken fresh step. And after taking fresh step, now I think it is more than 6 months.
Now, what is the status of the steps? Are you sure she is there?
She is there.
Are you sure?
I'm sure.
Lordship, LAC otherwise amicus curiae may be appointed to represent on her behalf, Lordship.
My lord,
No, service should be
Service,
complete.
yeah, that is there.
That is the
Lordship.
difficulty.
Yes, yes,
Well,
So what we are doing is, we are taking steps in terms of the notification,
No.
17 of 2019.
Through
of the-
PP office,
uh,
Lordship.
that-
Yes.
You just serve the copies to the registry. Rest is up to registry. Registry will send it to the PP. Now PP's office will send it to the local police station. Local police station will serve and finally report.
that has been followed.
Huh?
My lord, I have paid. I have filed one IM
For bail.
for suspension, yes, for suspension of the impugned judgment in order.
Let us see for once, let her come. Then we
It will take another time because the victim is more than 63 years now, very old. And the allegation is almost false allegation. Just you like.
No, that will go. What is her statement?
I'll say now. Just see page number 11 of my appeal petition. Page 11.
Page number?
Page number 11.
Why she was in CWC?
Child
If
welfare.
she's 63 years, why she was in CWC?
I don't know.
Huh?
I don't know. Earlier in the minor FIR,
Where is,
in the FIR, her age was shown as 17 years. In fact, as per the Aadhaar card and the voter ID, she was 25 years. Now, my lord, page 11, seventh paragraph. Allegation is that.
no, where is her evidence?
Oh, evidence, okay.
Show us her evidence. Now we are already convicted. We can only go to the evidence,
Yes,
nothing more.
Yes, I'll show you.
Where is her statement?
Just a second. Page number 47. It is cross 45. It starts from 45 now. there is full of contradiction and inconsistency in her statement, my lord. My lord, may I read the relevant part to save the time of the
Lordship, I have a prayer, Lordship. This is a Lordship.
Let him have this satisfaction. If there is no case at all, we'll consider.
Yes.
But
My lord, Lordship.
I can right now reject your petition if you insist.
Your Lordship would be convinced. If your Lordship go through the.
See, for the purpose of bail, you are convicted. I am not at all convinced because she has made specific statement how you have raped her. We are not, we'll hear in details. Today we are on a bail.
Yes,
Hearing will be different. Second part is in cross-examine, you have reaffirmed her.
My
Nothing more.
lord, just a second. Only.
Yeah, still a second,
Yes,
but don't say after 5 minutes that
Yes,
I am not pursuing. I'll
yes.
dismiss your petition
Yes.
right now.
I'm ready for that.
Ready?
Yes.
Okay, chalo.
My lord, kindly see.
Okay, we'll hear the finally here. Okay.
Page number.
Evidences are there.
Page number
Wait for your turn. We'll hear your, you'll finally hear
Yes.
this matter. But you are taking a risk.
Yes, I will take this. Because pendency is, my lord, it is worse than rejection.
No,
I
this
cannot
is not a case. This is
here
not a
and
case.
there.
This is not a case.
All right.
This is not a case. Yes, what is this?
In this case, although it is a submission of the respondents that the matter has already been settled by the parties, but we do not have any instructions from the clients yet. So we may be given some time in the interest of justice, Your Honor.
Lord, according to it is compromise.
Lordship, it's been 5 hearing, and I think the client has already instructed, and I'm appearing on behalf of respondent number 1, where the matter has been settled. That's customary institution, where both the party has contested the case. And
Any record?
yes, that's there in affidavit.
In affidavit?
Yes,
Where is that?
it's reflected in previous order also, last date order 2809. Lordship may refer that order. That order is very clear. On that day also, they were absent.
Last
20/09/2024. That's 20 September 2024. Since it's already in fractures, there's no at all case. And it's been settled in the month of February only. And
Yes, madam, this was recorded.
yes, everything is
Yes, Your
recorded.
Honor, although it is recorded,
You
I do
have
not
an
any
instruction by day after tomorrow. We are fixing it on Monday. Huh?
Lordship, actually, for same order that it's been 4 hearing, we are at.
You understand? She's saying she's not instruction. You either
Same-
come, you have a telephonic instruction. If not, then we'll say that on this basis, we'll close it. If it is not done, we have liberty to come again.
Yes, Lordship.
Monday.
Monday.
Though this court under its order dated 29/20/24 recorded on the basis of affidavit filed by the respondents that matter has amicably been settled, the learned counsel for the petitioner submits that she has no instruction to that effect, nor any reply affidavit has been filed against such affidavit filed by the respondent. In view of the aforesaid, a last chance is given to the learned counsel for the appellant to complete her instruction, whether they would like to object to such affidavit or whether there was any settlement as projected by the learned counsel for the respondent.
All that judgment, consent judgment and mutual settlement is also there in
Okay,
this.
that is
Yes.
good. No, they may
This-
say, no, this is manufactured. That's why if they are not coming, we'll close it.
They could not contact their client. I don't know why for last 4 hearing. For
Yes,
last 4
madam.
sitting.
We'll
So
be
we are
trying to
coming
contact
You obtain
without any
instruction
reason.
or say that he is not responding, I am withdrawing, we'll close
On
it.
Monday, we'll come with the
Don't
instructions.
appear then. Then we'll dismiss it for default.
Okay.
I
That
really
is the
oblige,
better
Lord.
option so that they can come later. Monday,
Oblige,
next Monday.
Respondent number 1.
What about 16? 15, 16, 17. 15, what about 15? Okay. Yes, what is this?
The Lordship, as per last order dated 5/9/2024, the respondent was supposed to file count objection.
What is the issue here?
The Lordship.
Issue.
Lordship, this is application under 482, sir.
For
Quashing of FIR and charge sheet.
quashing of FIR and search sheet.
Yes.
Now, what affidavit reply will file by them? We'll see the materials.
Sir, in this petition, they have mentioned that like we've put an allegation of false allegation against them. However, like we want to file an objection regarding on that thing.
Have you said in the FIR that this is a allegation?
Sir,
You want
they-
to file an objection?
Yes.
Any stay?
Yes.
Enjoy your stay if they want to file objection. What kind of objection is 482? Will you go by your objection? Will you go by your records?
Sir, since this matter has been going on in CGM as well, so
Huh?
this matter is going on in CGM court as well. After we have filed an FIR. So regarding on that thing,
There is a stay. It is against you. And you are seeking that you want to file objection. On the prayer of the learned counsel for the respondent, the last chance is granted to file affidavit in opposition. List after 3 weeks.
Interim may be called.
Interim order passed a lessel till the next date of listing. Definitely. No, 18. 18 was not 18. Yes, where the matters have come? IA?
May it please, Your Lordship. May it please, Your Lordship.
Yes.
My Lord, possibly today will be my first and last day in this case. I think I'll have difficulty in appearing here. Just now I have been informed that, my Lord, in fact, what happened after the elections in the Arunachal, at least from 5-6 constituencies, there was discussion. Some junior came and discussed. This is one of those cases. Possibly I cannot appear. Just now I have been informed.
Why? You have
Possibly from the counsel for the petitioner had taken some opinion at some stage. He filed, no, filing time I was not there. They themselves have filed. So at one point in time, some discussion was so. From 6-7 constituency, people came and consulted. I forgot. I cannot remember.
This is the difficulty with busy councils.
After I have been informed, I will not appear anymore.
Now who will appear for?
My engaging counsel was not there. He can appear. He will make submissions. I am just taking leave from this case. I am obliged, my lord.
We thought that we will have an assistance from you.
I'm sorry, my lord, but there is another case tomorrow. I'll appear before your lordship.
Okay, then
So-
other matter.
Yes, my lord. Tomorrow, my lord.
Yes, tell us, where is the, you have file
Yes,
objection? You
yes.
want to file objection?
I want to.
Of course. That's fine. Objection will grant. So therefore, since maintainability is there, will for the time being stall the
Filing of
filing
WS.
of the request.
I can understand that.
So please give me a schedule.
My lord, I'll go by your lordship's schedule. I'll not object to that.
No, because see,
because
you are also.
because I'm the
outpatient.
petitioner.
See, only one difficulty is there. If I sit in principal seat, here at least video conferencing is better. I do not know, but in Guwahati it's difficult from Arunachal. So, see now, what is the time frame from deciding this? Tell us. When will you be able to file objection?
My lord, I'll be able to file objection within a span of 2 weeks. Within 2 weeks, I'll file.
Why you need 2 weeks?
10 days. 10 days. May kindly give me. I have to go back and
You
prepare
want,
because
you don't you want to sit in the assembly? So you,
Lord,
earliest is the good for you. He may want to delay it.
you may want. I understand that because
Write it down. Write it down. In IA 198 AP. Okay. The present application is filed by the sole respondent, isn't it? Sole respondent under section 86, read with section 81 of the Representation of People Act 1951, praying for dismissal of the election petition. Full stop. Mr. Singh, learned counsel for the election petitioner, submits that he may be granted 10 days time to file an objection to this petition. Prayer is not objected, accordingly, same stance allowed. List this matter on. Give a date as after 10 days, give a date.
Fourth will do.
Huh?
Fourth will do. Yeah,
Okay, we are giving it on 5th.
my lord.
No, let us do one thing. Let us do, now I will have, you have asked for 2 weeks, na? I will have my own difficulty on 6th and 7th, because if we complete the hearing on that day, then I have to pass an order, na?
Yes, Lord.
So, November, 11th of November. Okay? 11th of November 2020. Now, come to IA 197, 1990. The present application is filed for deferring the filing of written statement by the sole respondent in the connected election petition for the reason that already an application has been filed by the respondent under section 86 of the Representation of People Act 1951, challenging the mentality of the election petition. Full stop. Which is registered as IA 198 AP 2024. Full stop. In the aforesaid matter, in the aforesaid IA, the aforesaid IA is fixed for determination on 11th of November 2024, enabling the election petitioner to file an objection in the meantime. In view of the aforesaid position, factual position, it is provided that till 11th of November 2024, the petitioner, that the date of filing, that the filing of written statement by the election petitioner stands deferred. let it remain IA. Okay. List in main election petition. In view of the order passed in IA 197 AP 2024 and 198 AP 2024 arising out of the present election petition, list this election petition on 11th of November 20. But tentatively, you think 11 November, then we'll decide. Then thereafter, we'll fix a date. If we allow this petition, then everything ends. If we say that no, this is dismissed, then issue everything. Tentatively, will not reflect in the order, but tentatively, we'll have an understanding.
Much obliged, Malak.
My lord,
Steps has been not been taken.
why you have not taken steps?
No, I'm sorry, my lord. I will take it by tomorrow.
Learned counsel for the appellant submits that he will take steps for issuance of notice upon respondent number 2 in terms of notification number so and so dated so and so. Okay, that is there is a notification. Are you aware?
Yes.
You'll have to date and service will be that you asked to yesterday we passed an order in division bench, or you ask Mr. Nath, he will give the details.
Obliged.
List this matter after 4 weeks.
Obliged.
Yes, what is this?
Yes, may I please, my lord? Hello, this matter is the filing for quashing of FIR. I represent on behalf of respondent number 2, my private.
I'll be appearing for petitioner, my lords.
Yes.
Please, my lords. I'm challenging the FIR. I'm coming under 40.
Where is the FIR?
Please, my lords. FIR is page 23, my lords.
Page
23, my lords. Am I audible, my lords?
Yeah, audible, but not so clear.
I take my lord's pardon, my lords. I'm appearing from Jammu and Kashmir. It's not possible for me to appear on each and every date before my lords, my lords.
Can you come down someday?
If my lords wants me, then yes, definitely.
No, we have no problem. We appreciate virtual hearing, but problem is that there are some connectivity issues here, and I think in Jammu and Kashmir also.
Yes, of course.
Because when I travel there, I got it. There is a maybe for the parent.
Please, my lords. I try to get my internet faster than I was having. Please, my lords. My lords, may kindly see page 23. My lords. Relevant is from page 24 onwards.
It will take some other day.
Please, my lords.
Give a date.
Please, my lords. My lords, November or December, my lords?
Uh-huh.
November or December?
You
Which
give a
month,
date
my
as per your convenience.
My lords, if it is possible, then it can be after 10th of December, my lords. If it is possible, I can give a date after 10th of December.
You give a date.
Yes, yes. Please, can it be on 12th of December, my lords?
Case record is there.
Lordship, yes, Lordship, we have received one case study, Lordship. That is on 12/9/2024, Lordship.
Statement of the victim is there.
Lordship, everything is here, Lordship.
12th of December, it can be, my lords.
12th of December.
12th of December, my lords, if it is possible for.
Okay, 12th of December.
Please, my lords.
As agreed to by the learned counsel for the parties, list this matter on 12th of December in the admission column.
Yes.
As pleadings are complete and parties are duly represented.
Please, my lords. Please, please, my lords. Highly obliged, my lords. Interim is there, my lords.
Interim order pass earlier shall continue till the next date of list.
Please, my lords. Please, my lords. Highly obliged, my lords.
Yeah, Lordship. Yes, Lordship, this is a criminal quashing under section 482 by the wife and husband, Lordship.
Wife and husband, where is the affair?
The FI is in Lordship, straightway to, it's in page 15, Lordship.
Page
15, 1-5.
1-5.
Yes. Married, Lordship.
Where one of the offense is 490.
Where is the medical?
It's a grievous injury.
Huh?
Yes, yes. 307 is there, trying to strangulate the wife.
On the prayer of the learned counsel for the petitioner, matter stands and there is specific observation in Lakshmi Narayan saying that 307 should not become.
Yes, if there is a material.
Maybe husband and wife.
Yes.
You cannot say you kill your husband and come on the prayer of the learned counsel for the petitioner. Matter stands adjourned and be listed effective.
Deeply obliged.
Difficult. 307 is really difficult. Better face trial, let her give her witness, matter ends there. Why should we entertain all this? Withdraw it, go there, face the trial. Both go together and get examination and cross-examination. None appears for the appellant on call, though the learned public prosecutor, additional public prosecutor is present. However, in the interest of justice, matter stands adjourned and be listed after 3 weeks. Obliged. Yes, Mr. Singh, what is this?
Lord, this is an application under 482, read with 439(2) of CRPC.
Cancellation of bail.
Setting aside of the bail.
Some other day.
If that is the case, Lord.
Because I will have to, either way, this is a contentious matter, I will have to deliver details as well.
Yes, Lord.
Law is in both sides, in both circumstances. One view is that no, once bail granted unless this is stricter view. One is nowadays a trend is slowly changing.
Slowly changing, and if that is perverse and illegal, if all these parameters are not considered, then bail is liable to be cancelled.
Let him be outside for some time.
Then, in that case, my Lord, may I make a humble submission, Lord, if the matter can be posted very soon, because
you tell us when?
As soon as possible.
What should be your as soon as?
Can it be in the first week of November? Yes. That's for because next week Manipur has got a lot of festival. I think you're also
okay.
So next week I'm not.
So 4th of November.
4th of November.
You have not been seen in Guwahati nowadays.
Well, Lord, sometimes I come, sometimes
we miss you.
I argued this thing one NIA criminal appeal for about 7 days before Justice Surana and Justice. And luckily, all got acquitted in 9 criminal appeals.
On
4th of November. All I see.
Okay, we'll take up your bail application first.
Yes. So the person foremost thing is that the convict is 63 years old, and the allegation is of rape. And if, let us see from the appeal petition, page number 11, it is my submission, and FIR. That will tell many things. Let's see past FIR matter. Page number 19 of the appeal.
Page 19.
Yes, yes. Hello, the first line, with the subject cited below, I would like to inform you that Sri Tapta sir, who is my maternal grandfather, as well as father-in-law, raped me for last 3-4 years. And 3-4 years. And this has been contradicted by the victim in her deposition line, in the cross-examination.
Where is that?
Page number 47.
Page number
47. Ninth line from the top. I was raped by Tapta sir about 1 year back for the first time at midnight at 12 p.m. In the FIR, she was saying she was raped for last 3-4 years. And now she is saying for the first time she was raped 1 year back. This is one contradiction. Now let us see another contradiction. From the FIR again.
What is this? From which file? Can we see?
From the FIR again.
Just a minute. Okay.
From the FIR again, my lord.
So first ground is that there is material contradiction between inner FIR and in the deposition.
Yes, yes. Full of contradiction. Now, my lords, let's see from the FIR again. In the second para, he has stated, my mother died when I was infant and my father got remarried to a new woman, and I was given away child marriage to my stepmaid, terming the victim girl as sterling witness. And what is sterling witness? That has also been explained in the judgment. Sterling witness. Page.
This is the difficulty. That's why I'm asking you. Difficulty is this, we are not getting it. We cannot at this stage of bail go and determine that she is not a sterling witness. We cannot in detail elaborately deal in a bail application whether these are contradictions simpliciter, or contradiction material. Is that it?
Yes.
And now you are insisting for this bail. You are convicted for 10 years. We'll make some observation in this bail. That's why I'm saying, why? So this can be a detailed argument in presence of the witness. So whether this is her witnesses can be sterling, then whether it's sterling nature or not. Because law is well settled that in a sexual offense case, a person can be convicted only the sole testimony of a victim.
Right.
But subject to the condition that court must have faith on her deposition, she starts trustworthy and sterling in quality, sterling quality in nature.
Yes.
History.
Yes.
And at the same time, we cannot come to any conclusion here, more particularly after conviction, that these are, she is not sterling, she is not trustworthy. We cannot.
Yes, ma'am.
So if we cannot, see, in a criminal appeal, we grant bail within 5 minutes, we are waiting that this is a case of acquittal. When we go into deeper into, we cannot grant you bail. The purpose is how I will reject your bail if you pursue, I'm telling you. My ground will be that in her deposition, she has specifically stated rape. In her cross-examination, she has affirmed rape. Now, whether she married, she was not married, whether trustworthy or not trustworthy will be a determination in the final argument. Then you may get an acquittal also. But on the basis of material, it is not a immediately prima facie case of acquittal. So therefore, we are not granting you bail.
Why I am agreed by.
No, I understand. Your argument may be a very good argument for the purpose of final hearing.
Yes.
Not for today.
Why I am pressing for.
You are pressing for the reason that he is for 1 year and the pressure is mounting upon you like anything.
Yes.
That why I am inside. I understand your lawyer's predicament. Because, so therefore, what we initially proposed is under notification 17, in looking at this, I was also a member of the committee. Looking into all this, we should, there was a judgment. Nayak.
Nayak is like.
Nayak judgment.
Nayak.
State of Orissa.
State Nayak.
Kotul Nayak versus state of some Nayak versus state of Orissa.
Deepak Nayak.
Deepak Nayak versus state of Orissa. There is a specific procedure has been laid down. Now you will have to give the copy to the registry. Registry will issue it to the office of the public prosecutor. Public prosecutor will send to the OC. OC will submit and give a report. And a public prosecutor will on the next day give that this is submitted. Matter ends there. So that's why I initially thought that. So option is still yours. Will you wait or I'll dismiss this IA?
I am agreed by the delay because.
So that's what I am saying. You are agreed by delay. We understand. So therefore, I will concluding this delay.
The delay.
Closing this delay, your anxiety is over that bail is rejected by the.
I will pray to seek a report from the OC PS Nahalai.
No report is required to be sought. The notification issued in terms of Deepak Nayak, na?
No, sir.
Deepak Nayak's case is already there. That is the notification issued under the signature of Honorable the Chief Justice, saying that this is to be the procedure. Now this is having a position of law. We need not separately pass order. The OC will have to give a report to the PP and PP will have to submit that before us.
My lord, that has not been done since last 6 months. That is the problem.
Okay. Yes.
No, so more about paper book need to be prepared.
Yes, let him. He is not understanding what I'm proposing. Yes.
No, my lord, my prayer is now, without pressing for disposal of the IA, regarding my lord,
service.
notice.
That is what I'm saying. It is seen from the record that though the petitioner, it is seen from the office record that the petitioner had duly taken steps for issuance of notice upon respondent number 2. However, service is not yet complete. In view of the aforesaid, the petitioner is permitted to take fresh steps in terms of the notification number so dated so. Full stop. List this matter on after 10 days. If you take steps immediately. Huh?
After completion of the service loss.
No, not completion. Then OC will sit over. It's not that. When can you take steps? In terms of the notification?
Within a week, I'll take a step.
Tomorrow?
Within 2 days.
Within 2 days. So if you take within 2 days, this place is placed from the Itanagar. Nahalagun. After 10 days. After 2 weeks. Give a date after 2 weeks.
After 2 weeks. No
problem. Give a date.
Specific date.
Specific date.
Today is 23. Can it be 5 November, Monday, Tuesday?
5th of November 2024. On the next date fixed, the learned public prosecutor shall produce the status of service before this court.
And in the meantime, can the record be called from the court below?
Record is not yet called.
Not.
Appeal is admitted. It was called received on last
Okay.
occasion.
In the meantime, the
It's not been received, Lord.
Huh?
It's not been received. It was already called. Lord.
Huh? Record is here. Record is here.
Because yes.
The paper book may be ready, Lordship, paper book.
Single bench by paper is required.
Sometimes it's necessary, otherwise, Lordship,
Let
it's
us
a
see,
convenience.
at least if she not come, we can consider his IA. Yes, this paper, this record is there. Okay, that is the order. You submit, you just intimate, moment you receive, you intimate that please give this report is pending. Let him say.
Right.
Okay. That notification you should keep here. Deepak Nair. Get it downloaded from website and
I
keep.
will furnish.
You furnish and you furnish it one to him also.